Hi, David Eastman here with Eastman Estate Planning, and the topic that we're going to discuss today on this YouTube video is going to be what is probate and how do we avoid it. Probate is basically the legal process that we go through when somebody either becomes incapacitated or passes away, and that incapacitated person or that deceased person owned assets that we're now trying to get in control of or trying to manage for that deceased person or incapacitated person. So there's two types of probate that we're always worried about. One is one type of probate that most people are familiar with, and the other one is one that most people are not familiar with. But there's something called living probate and death probate. Living probate is where we have a person that is alive, but they're incapacitated. So they have Alzheimer's or dementia or something like that, and they can't manage their financial affairs anymore. If they don't have proper documents in place, like a financial power of attorney, or they don't have assets that are jointly owned, or something like that, then we have to go to court so that we can get what's called a conservatorship issued over that person, so that that person the court appoints will be able to have the authority to manage those assets. So as an example, if I have $1 million brokerage account sitting at Charles Schwab, and it's in my name, Dave Eastman's name, and I'm driving home from work and I get in a car accident, and I don't die in that car accident, but I become incapacitated. If my wife wants to access that Charles Schwab brokerage account with $1 million in it to help pay bills or medical expenses or whatever, the only way she's going to be able to do that is by going through something called living probate and getting a conservatorship issued over me, unless I had a legal document called a financial power of attorney that gave her the authority to do that. So that's called living probate. And why do we want to avoid that? Well, it's easy to understand. Probate means we're in court, which means if we're in court, we got attorney's fees, we got court costs, we got the delay that goes with court, and court is all public. It's not private. And so everybody gets to know what's going on and what's happening with our personal affairs and our matters. So that's living probate. The other type of probate is called death probate, and that's the one most people are familiar with. And that's where somebody's passed away and they owned assets that were just in their name. There was not a beneficiary designation on the asset. There was not a joint owner on the asset. It was just in the deceased person's name. They owned it solely. And the amount that person owned, the dead person owned, exceeded the probate threshold amount in the state that they lived in. So in Arizona, that amount is $75,000. And if we have assets that exceed that dollar amount, and those assets are just in the deceased person's name, and we have no other legal documents in place, like a trust, then those assets have to go through probate. And so if I give you the same exact hypothetical as before, I've got $1 million brokerage account sitting at Charles Schwab, I'm driving home from work, I get in the car accident, I don't become incapacitated, but I die in the car accident. Then how does my wife gain control of that Charles Schwab $1 million brokerage account? If she walks into Charles Schwab and says, here's a death certificate, give me control of the account, guess what Charles Schwab is going to tell my wife? Who are you? Why would we give you control of the asset? That's what they're going to tell her. You have to prove to us that you're the legal rightful owner of this account, and we should be giving you control of the account. How does she prove that? She opens up probate. She gets what are called letters testamentary, letters personal representative from the court, which the court signs off on, gives those to my wife, and then she takes those letters back into Charles Schwab, and then she gains control. But once again, we're going through probate to do that, which means attorney's fees, court costs, delay, the expense of the court, publicity of court, all the junk that goes with court. So that, in a nutshell, is what probate is. We're trying to avoid it. What I tell most of my clients is, what I ask most of my clients is, would you ever sue yourself? Would you ever take yourself to court? And most of them look at me like I'm crazy. Of course I wouldn't do that. Why would I do that? Well, that's what you're doing if you don't plan appropriately, because you're forcing your estate to go to court after you die or become incapacitated if you don't plan properly. And make sure you have the proper legal documents in place to avoid both living probate and death probate. Hope that helps.